Na mtazamaji, basi hivi sasa nakupeleka moja kwa moja katika mahakama ya juu ambako kunaendelea ile kesi. Tayari inaarifiwa kwamba majaji wakuu wamewasili katika kuendeleza kikao hicho cha jioni hii. Tukutane tena baadaye kwa taarifa zaidi.
Yes, good afternoon.
Good afternoon.
Which for the first respondent, is it Mr. Katonya or Muhor?
For the first respondent is my senior, Mr. Katonya.
Okay.
My Lord, before Mr. Katonya takes this case, I bring the attention of the court some difficulty we are experiencing with the orders of access we were given this morning. I sent my team to the IBC after I confirmed from my colleagues that we would go to Anniversary Towers, which they did soon after the orders were issued. And they have sat in some room without any exercise. And the reasons they were given was that they cannot commence until the third respondent's representatives are present. And thereafter, they were told to wait until 5 o'clock. Up to this point, the third respondent, who in any event had objected to our application, has not sent his representatives to Anniversary Towers. The second bit is rather mind-boggling. We have received a letter from Senior Counsel Lucy Kambuni asking that we deposit an amount of Kenya shillings 80 million to facilitate the photocopying of the register. Now, my Lord, even if you assume we are 20 million voters in Kenya and that each voter has the one page in a register, it would take, and if you were to photocopy at 20 shillings per page, you would only need 40 million. Asking the second and third petitioners to pay 80 million shillings in advance is difficult to understand the basis. Very, very difficult to understand the basis, but we see this as a hurdle, or rather measure of difficulty we are being put into so that we do not realize the objective of the order that the court made. So if the court may direct that the third respondent, if it's not interested, fine, but the first respondent should provide the access immediately as we expected in the morning. Thank you.
My Lord, my learned friend, Mr. Sisude, will respond to the complaints made by my learned friend.
My Lord Chief Justice, my Lady Deputy Chief Justice, judges of the Supreme Court, the exercise that you ordered to start, the commission started immediately. The chairman issued instructions for that to start immediately. Initially, it was going to happen in the warehouses, but to facilitate the process, the commission decided to move all the forms to Anniversary Towers, 21st floor, which has been done. The forms are there. What was being organized was the rooms for the exercise to start. I believe it should start shortly. As far as we are concerned, we were not waiting for the third respondent because the third respondent had indicated they will be available. That is on the forms. With respect to the question of printing the register, you will notice, my lords, my ladies, that in the affidavit of Njeru, which was the reply by the commission, that figure was actually indicated. Now, there are two ways of doing this. There is a factory production of the register. It is 450,000 pages. If it is to be produced within the time that is remaining for this court to sit, it requires to be done in the factory. That will take about 2 days. And that is the cost of production. If it was to be copied in Kenya at the normal rate of photocopying or printing, it will take about 2 weeks. All that information had been provided in the affidavit that was put before the court, and the petitioners had that affidavit. They did not contest the cost. They did not contest the time, because it was explained if you need it within the time period factory production, that is the amount of money needed. But if we do normal printing, which would take 2 weeks, then the cost will be probably lower, about 40 million he's talking about, but that will take 2 weeks. Then it will defeat the purpose. So that is the situation as we speak. It was put to court in a deposition. So it's not something that has come up now.
My Lord, I think that's a fairly...
Let's hear Mr. Angazia first.
Okay. Sorry.
I'll need to remind my good friend that there is a third respondent. My Lords, since the proceedings are being transmitted live, I have got a message to the effect that the process has started at Anniversary Towers. My team of 7 are there, and the team from him are also there.
Okay.
It has started.
Yes.
If he wishes, he can make a call and confirm. As regards the cost, that is really a matter. You want 450,000 pages, there is a cost to pay for it. You can't ask for something and then not have the will to pay for it. But the process is now going on.
My Lord Chief Justice, if I might just assist the court, we had indicated earlier that the register in soft copy is readily available and the Commission can provide it immediately. However, the petitioners want a printed copy. The facts are that that is how big it is, and that is the cost of producing it from a factory at that speed.
Lord, if you may refer to Article 48 about access to justice, the state is bound.
Mr. Nduvi, you are not applying to revise our order.
No. I'm not seeking to revise. All I'm saying that this access to justice must be reasonable and accessible. Now, and I ought to be, if any fees were required, it shall be reasonable and shall not impede access to justice. Now, this fee they are asking for from John Jumue and the Khalef Khalifa of 80 million is completely unreasonable. We will not afford it, let me say bluntly. Perhaps in the alternative, we can then make arrangements to see if we can get a soft copy of it, which they assured me will be for free. And then we can move forward on this. But it is definitely going to be impossible for us to raise that cost of 80 million shillings.
You can do that, Mr.
My Lord, yes, if the court asks us, we can do that. We had offered it from the beginning. The register in soft is available for free.
Okay. So can you sort that out, Mr. Ndubi? Because that cost was in the affidavit. That cost was in the affidavit. Whatever, okay, whether it is what, astronomical or what, you know that printing out the register, and I believe there are these large sheets, isn't it?
Yeah. It's A3 paper.
Okay. Printing that was not going to be cost-free.
Yes, but I thought the state would assist us on this. This is the state. This is the state that is supposed to facilitate its citizens. But
when it is in soft and readily available, that is what we took into account.
Yes,
we took it into account, the fact that this register is in soft and it is readily available.
We are undertaking
so
to
if you go ahead and demand, a printed copy, surely you pay for it.
I hear you, my Lord. Yes. Thank you.
We'll provide the soft copy.
Thank you. Mr. Gatonya?
Yes.
Yes.
Thank you, my lords, for giving me this opportunity to respond to the case by the petitioners.
We have given you 1.5 hours,
Yes.
and since Mr. Muhoro has also 1.5 hours,
Yes.
but if you can do it, and knowing you as senior counsel, you can do it for less than that time.
Well, my lord, I'll try to be very brief.
Yes.
But in my team, I also have my learned friend, Mr. Karuri,
Yeah.
who will deal with the withdrawal of a candidate who has been mentioned many times, and also try to interpret Article 138(2) of the Constitution. Then my learned friend, Mr. Mahati, not Mohati, my lord. Yes.
I made that mistake
You
yesterday.
deal with the issue of numbers and
Yes.
the ICT. And my learned senior friend, Lucy Kambuni, will deal with some comparative jurisprudence relating to elections. We'll try to keep within the time that has been given to us. So, my lord, if I may begin by making this observation, that there are no perfect elections anywhere in this world. In Kenya, my lord, this year, we have had 2 elections. One on the 8th of August, 2017, and another one on the 26th of October, 2017. My lord, when my client, the IBC, conducted the election of 8th of August, they were dragged in court on the basis that there were many irregularities and irregularities that were committed. And my lords, you did find that the elections were not in accordance with the law, and you invalidated them. The more important thing here, my lord, is you made an order that a fresh election should be done in strict conformity with the Constitution and other applicable laws. My lord, we took seriously the order that the election should be in accordance with the Constitution and the applicable laws. We tightened our procedures on ICT. My lord, we also transferred personnel and constituted a new team to carry out the elections. Another important thing, my lord, that we did was to involve all the important stakeholders in the presidential election. And above all, my lord, we did involve ourselves or pursued a policy of transparency so that we kept in constant communication with the people of Kenya and all those who are interested in the elections. As you will be demonstrating, my lords, through the submissions that we are going to make in succession, it is our humble submission that we have delivered in accordance with your order of the 1st of September, 2017. But a number of objections, a number of grievances have been brought to your lordship with a view to invalidating these elections like the last. Those matters, my lord, will be dealt in succession in accordance with the order, my lord, that I have read to you earlier on. For me, I'll be content to speak to the issue of nomination, which has occupied your lordships a lot of the time today. May I make this opening statement about nominations, my lord? Nobody has approached any of our courts complaining that he or she wanted to stand for the presidential elections on the 26th of October and was denied the opportunity to do so. All those who are before your lordships by way of petitioner do not purport to have indicated any intention at all to stand for the presidential elections on the 26th. My lord, we have heard the argument from the petitioners that every presidential election must be preceded by a process of nomination. My lords, it's our humble submission that that submission by our opponents constitutes a misunderstanding, a misapprehension, and a misinterpretation of the relevant provisions of the Constitution and the applicable laws. So, my lord, we begin from this point. Upon your lordships making an order that a presidential election be held, what was the law applicable at that time? My lords, there cannot be any doubt that the laws applicable included the Constitution, the IBC Act, the election regulations, and the applicable case law. And my lord, we begin with Article 140, Sub-Article 3. Unlike my lord, in Article 146, Article 138, apart from prescribing that upon invalidation of a presidential election, a fresh election shall be had, there are no other provisions at all, my lord, as to how that election is to be conducted. So, my lord, we need to look elsewhere to see whether there are other provisions that come into play. And I start, my lord, with the Section 2 of the Elections Act, which defines a presidential election. My lord, Section 2 defines a presidential election to include a presidential election conducted under and pursuant to Articles 136, 139, and 146. My lord, it's quite clear that by Section 2, the presidential election ordered by the court under Article 140, Sub-Article 3, is excluded from the provisions of the Elections Act, in particular, Section 14. In my humble submission too, my lord, this is also exempt from Part 14 of the Election General Regulations, which only deal with a situation where there is nobody elected as president and an election has to be done. And that, my Lord, in the search for purposes of ascertaining the law that was applicable, takes me to Rider 2013, paragraph 289 and 291. This is a case, my Lord, that is well known. Many of you participated in that case. And there are three important deductions we can make from that judgment. It came out very clearly, prompted by some questions that had been put by the learned Attorney General, that in an election arising from an invalidation of a presidential election, there was no basis for new nomination. Number two, my Lord, only the candidates who had taken part in the void election would qualify to stand in the fresh election. Because, like your lordships or this court observed, the fresh election is based on the election that had been invalidated. And the court went on to say, only the person who had been declared elected and the runner-up would qualify to run. And my Lord, before the election that you had ordered could be organized, upon one Ekuro Aukot, who has been allowed into these proceedings as an interested party, learning that he had not been made a candidate, he ran to the High Court, and there was an interpretation of the Constitution in the light of Rider 2013. And my Lord, an order was issued to my clerk compelling them to include Ekuro as one of the candidates. And number two, my Lord, the High Court expressed the clear view that even though those others who had stood in the invalidated election should also be included as candidates. My lords, my clan had no other choice other than to go by what Rider 2013 had said and the Mativo judgment which interpreted the Rider 2013. Allow me, my lords, to make two comments about Rider 2013. My lord, it is said that it is not binding because it was obiter dicta. But to good students of law, a statement of law by the apex court of the country, whether it be obiter dicta, is entitled to the greatest respect. and cannot be disregarded except for a good reason. So the position, my Lord, existing at the time that the election was to be done was such that our client was bowed by these two decisions of superior courts in our country. But, my Lord, we also need to look at, although I do not want to go into details, if you look at the procedure preceding a presidential election, it involves a lot of steps, many steps, my Lord. Nomination by the parties, consideration of candidates who have moved from one party to another, and at the time that is specified by law, that one is supposed to have been a member of a party that may nominate him. There's quite a number of things, my Lord, that are done before the elections are conducted. My Lord, if, like it is argued by the petitioners, it was that nomination had to be done. Clearly, my lords, it would not have been possible to do nominations and other preceding matters before the expiry of 60 days. And the order, my lord, that you had made, and the constitutional imperative that is envisaged by Article 140, Sub-Article 3, would have been defeated. And, my Lord, it cannot be that the makers of the 2010 Constitution intended that such an absurd result should be the result of interpretation of Article 140, Sub-Article 3. We all know two important rules or canons of construction of our Constitution. One, my Lord, is the canon of harmony, of fullness. Two, of considering every provision, because all provisions of the Constitution are constitutional and are meant to be operationalized, to be implemented. To use the language of Article 259, my Lord, that the Constitution shall be construed in a manner that the law is always speaking, that it is interpreted in a manner that the objectives of the makers of the Constitution are realized. And so, my Lord, when we look at Article 140, Sub-Article 3, it comes out quite clearly that what the makers of the Constitution meant was give another chance to the electorate to vote a person of their choice. And I would, with great respect to your lordships, request you to give an interpretation to Article 140, Sub-Article 3, which does not defeat that purpose, to enable the people of Kenya to vote again in a situation where the president-elect's victory is cancelled, is nullified. That is the purpose, my lords, of Article 140, Sub-Article 3. My Lord, if I may refer you although you said we can just refer without having to cite the particular part. The case of Law Society of Kenya against the Kenya Revenue Authority, I had the fortune to argue it in the Court of Appeal. There is quite a bit of a good principle set out there on the principles that ought to be applied by the court, particularly to our constitution, so that its objectives is achieved. There is another case, my lord, I will be giving you the citation later. I do not have it right away. It was decided the other Friday by the Court of Appeal. It's also very good. I think we have heard of the MCAs who went to the High Court. They got a judgment for 80 billion Kenya shillings for the period that they had not served. The Attorney General appealed to the Court of Appeal, and the Court of Appeal has delivered a landmark judgment on constitutional interpretation. And I liked the way they have dealt with the issue about the canons against absurdity. My Lord, it's part of our list of authorities. We'll be getting you the citation. So, my Lord, my submission in this regard is give Article 140, Sub-Article 3, that interpretation that will not defeat the makers of the Constitution, which must be quite clear, my Lord, to give the people of Kenya a second opportunity to vote quickly, to vote within 60 days after the invalidation of a presidential election. Perhaps, my Lord, before I wind up, I would like to refer you also, my Lord, to what I believe is the justification for not requiring nomination in the case of a fresh election pursuant to Article 140, Sub-Article 3, by referring your lordships to Rule 8 of the Supreme Court Presidential Election Petition Rules. My Lord, that rule provides the grounds on which a presidential election petition may be launched with the court. One of the grounds, my Lord, that is provided there is nomination. The clear position, my Lord, was in the August 8, 2017 election, the issue of nomination was not at all pleaded, neither was it canvassed. My understanding, my Lord, is if nomination was not one of the grounds of the petition that led to the invalidation of the election, then my understanding would be that in the repeat elections, if I may call them so, my lords, you do not require to conduct a nomination exercise. So, my Lord, I wind up by making this final summation that upon a consideration of the applicable laws and the facts pertaining to this matter, there was no legal requirement for a nomination process to be conducted by my client. Indeed, the existing law at the time required them not to conduct any nomination, but to proceed with a fresh election on the basis of the candidates who had stood in the invalidated election. My lords, I would like to keep within the time that your lordships have given us. Unless there is any question, I would be quite happy to rest my argument there. I'm grateful, my lords.
Thank you, sir. Antonio? Yes, Mr.
May it please, my lords. My lords, on behalf of the first respondent, I'll be submitting on the twin issues that Malala Senior talked about, which is the question of Article 138(2) of the Constitution and the question of withdrawal of a candidate. And because of its breadth, my lord, and because of the time that I have, I think I would want to start with the question of Article 138, sub-Article 2 of the Constitution. Now, my lord, in the course of the submissions that have been made before you this morning and a bit of this afternoon, you are told that the Constitution at Article 138, sub-Article 2, requires in mandatory terms that an election must be held in each and every one of the 290 constituencies, plus the diaspora and prisons, making a total of 292. And my lord, there is no dispute about that. That is what Article 138, sub-Article 2 says, and the terms of that provision are clear. But so that, my lord, I can be able to explain the circumstances that obtained in this case, I think let me first of all set the following background. My lord, under the Constitution of Kenya, the obligation to respect and uphold the Constitution is not uniquely reserved only for public institutions. Under Article 3 of the Constitution, every citizen, every person, in fact, my lord, if I may read the words to you, it says every person has an obligation to respect, uphold, and defend this Constitution. Those are the plain words of Article 3. Now, my lord, why is this important? This is important because, my lord, the fresh presidential elections that were held were being held under two circumstances. The first one is there was an order of nullification of the elections and a clear and a specific order from this court that fresh elections must be held within a period of 60 days. That is one. That is the decree and command of this honorable court. Secondly, there is a decree and command of the Constitution itself. Under Article 140, sub-Article 3, the law requires, the Constitution requires, that a fresh election must be held within the same period of 60 days, so that the immediate effect of a nullification is that fresh elections must be conducted within that period. And my lord, the point I'm making is this, that once that order was made, IEBC, or the Commission, was under an obligation to ensure that those elections are held within the time set out in the Constitution and are set out by the court. Now, my lord, once this order was issued, the Commission set about making sure that the fresh elections were held within the time set out by the Constitution. And what did it do? My lord, in the affidavit of Mr. Marjan, which I will be relying on extensively, and this, my lord, you'll find at paragraph 10 to 53 of that affidavit of Mr. Marjan, he sets out what he calls preparedness in the run-up to the fresh presidential elections. And some of the key things that were done were this, my lord. The Commission employed electoral officials for all the 290 constituencies, without exception, so that there was no discrimination against any of the constituencies. 290, so that in total, my lord, there were 40,883 presiding officers that were appointed, 40,883 deputy presiding officers that were appointed, and the polling clerks. A total, my lord, of temporary employees of about 300,000 people were employed to supervise the conduct of the elections in all the 292 constituencies that I've explained. So that the beginning point is that IEBC set out to conduct elections throughout the country because it was a national election. My lord, what happened after after these arrangements were put in place is captured, my lord, in the petition that has been filed before you. At page 6 of the petition, number 4 of 2017, the petitioner says, in the meantime, The fourth respondent and their supporters, which is NASA, launched petitions and commenced public demonstrations and picketing against the second respondent and against the conduct of the 26th of October 2017. Now, my Lord, remember, I had just referred you to Article 3 of the Constitution, that everybody has an obligation to respect and uphold the Constitution. And my Lord, at paragraph 88 on page 26, the petition reads, meanwhile, the fourth respondents also engaged in what it termed no reforms, no elections, and later on encouraged its supporters to boycott the fresh presidential election. The campaign mostly took the form of demonstrations, which included some violent demonstrations. Now, my Lord, by way of example of the situation that the Commission then found itself in, we have filed a number of affidavits by constituency returning officers for various areas, and this is, my Lord, attached to the affidavit of the chairman of the commission as annexure WWCA 18A. And my Lord, it is important that I refer you to this particular affidavit. My Lord, it's a document of written index, and it has a number of affidavits for returning officers for various areas. And my Lord, if you go through the affidavits that have been filed, three things clearly come out. The first, my Lord, is that there were efforts that were made by the Commission to train electoral officials in all the 292 constituencies. Secondly, that the Commission took steps to procure and transport election materials to all the 292 constituencies in the country. But, my Lord, in respect of certain areas, they were prevented from being able to carry out, or rather to transfer the election materials to the polling stations, and the circumstances under which this happened are set out. In fact, my Lord, if you look at page 6 of the first affidavit that is attached, you will find the photograph of one of the officials of IBC with bloodied face and clothes because they were attacked. And there is a description of how this happened. So that, my Lord, the commonality of the arguments that have been advanced before you today is that while the Commission took steps to carry out the elections in those areas in accordance with the command of this court and in accordance with the command of the Constitution, in several areas, they were prevented from carrying out that function by the violence that took place in those areas. And so, my Lord, the question then becomes, under Article 138, under Article 132.8, there is a requirement for the elections to be conducted in every constituency. But what happens if, by reason of factors beyond the control of the Commission, it is not possible to carry out those elections? Is the Commission helpless? And the simple answer, my Lord, is it is not. Under Article 82 of the Constitution, my Lord, Parliament was required to enact legislation to provide for, among others, the conduct of elections and referenda, and the regulation and efficient supervision of elections and referendum, including the nomination of candidates and so on. And so, my Lord, in the exercise of this power, Parliament enacted the Elections Act. Under Section 55 of the Elections Act, my Lord, Section 55B, which was introduced through a bipartisan process undertaken by members of Parliament and the Senate. In fact, it was headed by the Honorable Orengo and the Honorable Kreitu Murungi. The law, the Section 55B of the Constitution was introduced, 55B of the Elections Act was introduced for purposes of dealing with situations where the Commission cannot be able to carry out elections because of two factors. The first one, my Lord, is where, because of violence, or what is referred to as breach of peace, it is not possible to carry out elections. That is the first one. The second one, my Lord, which is 55(1)B, where it is impossible to conduct the election as a result of a natural disaster or other emergencies. Now, what happened, my Lord, on the 26th is that apart from the violence that I've referred, my lords, to, in two constituencies, or in two constituencies of Turkana Central and Fafi, because of flooding, it was not possible for election materials to reach that region. And so because of violence in four counties in the Nyanza region, and because of flooding in the two areas that I've referred to, the Commission used the tools provided to it under Section 55B to postpone the election up to the 28th of October. Now, my lord, on the 28th of October, elections did proceed in the two other areas. In Turkana Central, the elections proceeded on the 28th. In Fafi, the elections proceeded in 28th. So that the remedy for inability to conduct an election is provided for under Section 55B, and it was applied in connection of Turkana Central and Fafi, and the voters there conducted the elections. But my lord, at that point, the Commission then wrote to the security agencies and inquired whether it is possible to conduct the elections in all the other regions in view of the insecurity that had been witnessed up to that point. And the response, my lord, received from the Commissioner of Police, and particularly, my lord, from the Ministry of Interior, was that it is not possible to conduct those elections in those regions because, my lord, and probably it's easier for me to read for you what the Ministry of Interior said. My lord, in a letter dated the 27th of October 2017, which was the day before the 28th, the Principal Secretary, my lord, then said, this office has received information that tension remains high in parts of Nyanza region ahead of the repeat presidential elections scheduled to take place on Saturday 28th. This has been exacerbated by the ongoing propaganda of insightful messages by politicians and the clergy. The persisting charged and volatile political environment in this region is a pointer to more intensive demonstrations punctuated with deliberate acts of violence and criminal acts. In this regard, in order to avert further loss of life and property, there may be need for IBC to call off the exercise. And now, my lord, apart from the fact that this letter was written, I've also referred you to the affidavits of the returning officers who had also explained to the Commission that it will not be possible to carry out the elections in those regions. And so as a result of that, my lord, it was therefore necessary for the Commission, again, using the tools provided by Section 55B1A, to postpone the elections. And in the words of the Act, my lord, it is to postpone the election for such period as it may consider necessary to be able to carry out the elections without a serious breach of peace. And so, my lord, all that the Commission did is that it postponed the conduct of the election. You are told today in the morning that the IBC or the Commission cancelled the elections. It did not. It postponed the elections until such time as the situation would permit the conduct of the election in a peaceful environment as provided for under Article 81 of the Constitution. Now, my lord, the interesting thing about this is that the criticism against the Commission is that it conducted elections in an environment where there was violence and breach of peace. The reality, my lord, is that the Commission had postponed the election for that very purpose, to ensure that there was protection of life and property. Because if it had insisted on conducting those elections in the environment explained by the returning officers and as explained by the security agents, it would be putting the lives of the residents of that area at risk and also the lives of the election officials. So it is in fact to ensure that the elections conducted were in accordance with the provisions of Article 81 that it adjourned or postponed the conduct of elections in that region.
Mr. Karori.
Yes, my lord.
You know, that's an important point.
Yes.
The complaint by the petitioners is that there was cancellation.
Yes.
You are going by 55B
Yes.
and saying there was postponement.
Correct, my lord.
Postponement to when?
My lord, what had happened is that, and I think that was my starting point, I said that the conduct of this election was within strict timelines that had been given by the court, so that the election had to be concluded within the time-bound period of 60 days. that time was to lapse on the 31st of October at the latest. By the 31st of October, the situation had not improved to the position where it would be possible to conduct those elections in accordance with the provisions of Article 81. And so, my Lord, at Section 55, if you read the provision of Section 55, you're supposed to postpone these elections until the situation is such that you can be able to conduct those elections in strict compliance with Article 81E. And, my Lord, so according to the Commission, that would only have taken place upon satisfaction that it's possible to conduct those elections in accordance with the provisions of Article 81. Now, my Lord, the other tool that is...
I need to be clear my mind.
Yes.
So that if then you postpone until the end of the 60-day period,
yes,
what then is the meaning of 55B3?
Yes, so now, my Lord, 55B3, I was going to come to that as the other tool.
Oh, you're coming to it. Okay, okay. Then
I'll to that as the other tool.
I will wait, I'll wait.
Yes, yes.
Okay.
So, my Lord, once the elections were postponed, then the question that came up is this. Now that elections have not been conducted in those regions, is it possible to declare the result of the election in the absence of the results being received from all the 292 constituencies countrywide? And that is where Section 55B3 then comes in. My Lord, it provides that notwithstanding the provisions of this section, the Commission may, if satisfied that the results of the election will not be affected by voting in the area in respect of which substituted dates have been appointed, direct that a return of the elections be made. So that, my Lord, as of the 30th of October, the Commission had received the results from all the other areas of the other regions of Kenya, my Lord, and that by that date, the person who was the leading candidate had already garnered more than 50% of all the total votes cast, and more than 25% in more than half of the counties, and therefore had complied with the provisions of Article 138(4) of the Constitution and was entitled to be declared president. So the consideration that then came up is this. What consideration or what position would the Commission take in respect of the votes for the regions where votes were not cast? And, my Lord, at the time of declaring the results, the leading candidate had a total of 7,493,895 votes. Now, the total number of votes cast, or the total number of registered voters in the regions which had been excluded was 1,862,671, which means, my Lord, that even if all those votes were counted for the person who was the second, at most what would happen, my Lord, is that the leading candidate would still, his percentage would reduce, my Lord, to 79%, meaning he would still have surpassed the threshold required by Article 138(4). And therefore, my Lord, on that basis, the Commission was entitled to declare the results on the basis that even if all those votes were considered and applied to the second person, it would still not alter the outcome of the elections. So that, my Lord, as I wind up on this area, my Lord, postponement of elections in the affected areas, my Lord, was expressly contemplated by the law. Section 55B was introduced specifically to deal with circumstances such as the ones that obtained, where it is not possible to conduct elections without a breach of the peace. Because, my Lord, it would have been, I think in the absence of that provision, it would have been impossible to comply with the provisions of Article 138(2). Yes, my Lord? Oh, okay. My Lord, and I say this, the fact that the Commission was entitled to rely on Section 55B is not disputed by the petitioner because they have created a different narrative and say that the Commission cancelled, and so that the complaint before the court is that it was erroneous for the Commission to cancel the election. The elections were never cancelled. And so to that extent, there is no dispute that the Commission was entitled to proceed in the manner that it did.
What term do you want to use for the decision of the Commission not to go on with the election in those constituencies?
Sorry, my Lord, I didn't get that.
What term do you want to apply?
My Lord, it was postponed. The elections were postponed until such time that the circumstances would have allowed for those elections to be conducted, other than the fact, my Lord, and maybe this is an issue that the court, we think, ought to give a view on, a position on, that where the court has commanded elections be held within a specific period of time, and where because of circumstances beyond the control of the commission, it is not possible for those elections to be conducted in certain areas.
You know,
postponement, yes.
Postponement implies that you are going to go back.
Yes, my lord, it does.
Yes.
That is the point that I'm making. Because, my lord, we are operating in very unique circumstances. It is the first time that an election has been nullified, my lord. It's the first time that we are dealing with the question of how to conduct an election subsequent to a nullification order. I think it will be necessary for this court, my lord, to give guidance in situations such as this. What is the commission to do? But the critical question that I want, my lord, to answer and to ask is what was asked by my learned friend, Ms. Soweto. She says, how much violence is it necessary to occur before the commission can take certain steps and so on? But the more important question, my lord, would have been, how much violence did they want to, would the commission have waited to take place before it said, we need to postpone these elections? Is it to wait until people have been killed? Is it to wait until property have been destroyed? And so, my lord, it did the correct thing in taking the decision to postpone the election to save loss of life and destruction to property.
Counsel, I would like you to clear something in my mind. What difference would it have made if
yes, my lord.
IBC had indeed cancelled the election rather than postponed?
Two things, my lord. First of all, under Section 55, there is no power on the part of the commission to cancel the election. There is no such power. Secondly, the Constitution commands that the election must be held within a period of 60 days. Thirdly, this court ordered that the election must be conducted within a period of 60 days. In fact, my lady, if you remember, I came back here with an application for clarification. And the question I remember, my Lord Justice Lenaola asking me is, we told you to go and conduct an election. What else do you want us to tell you? And so, my Lord, that's the exact position that we find ourselves in. The option of not conducting that election, my Lord, was not there.
And the chairman never used the words cancelled?
No, my Lord,
Never.
He says it's actually postponed.
He said postponed?
He said postponed.
Thank
Just 4 minutes. My Lord, the only other issue, my Lord, that now I wish to deal with is the question of withdrawal of the NASA candidate, and this is the easier of the matters that I have to deal with, because, my Lord, at this point, my learned friend has already dealt with the position of the law as it obtained at the time at which the court made the orders that it did. But the critical issues, my Lord, that I just wish to make quick comments on here are these. At the time the order was made for the holding of fresh elections, there was another order that was made by this court. My Lord, when the first interested party appeared before your lordships and raised the question of whether or not he's a candidate for purposes of the fresh elections, in the judgment delivered by the court recognized and said there is a question of what is the proper interpretation of Article 143. In the first instance, in the judgment issued by the court, it had said that issue will be dealt with on the merits. But subsequently thereafter, the Honorable the Chief Justice directed that to the extent to which there was a requirement of interpretation of Article 143, that's an issue that should be dealt with by the High Court. And therefore, the question of who are the candidates for purposes of the election, pursuant to an interpretation of Article 143, fell to be determined by the court, by the High Court. And my Lord, what happened is this, that when the parties appeared before the High Court, the candidate who states that he had withdrawn supported the application for inclusion of a third candidate. And my Lord, by the time there was a letter written saying that he wishes to withdraw from the election, it was a day before a judgment on a matter in which his party had participated was to be delivered. There was no application to arrest the judgment. And so, my Lord, all parties, including that candidate, was aware that there was a judgment that would be delivered that would have an impact on the question of who are candidates for purposes of the fresh presidential election. And my Lord, as indicated, the High Court did decide that all the candidates that participated in the 8th of August election were entitled to participate in the fresh presidential election. And so, my Lord, the scenario envisaged by that candidate where there would only be 2 candidates was removed. Immediately the judgment of the High Court was rendered. So that the argument that the withdrawal then meant that the consequence would be that there would be a new election and so on did not exist. Why? Because that scenario covered under the Raila 2013 decision had been removed by the decision of Justice Mativo. And that decision, my lords, as you know, or as has been submitted, is pending an appeal in the Court of Appeal, pursuant to the principle of hierarchy that this court has already established, and ripeness, my lord. That issue is not ripe in any event to be canvassed before this court. And so, my lord, the commission operated on the basis of the law as interpreted by the courts, first by the Raila 2013, and secondly by the High Court in the Ekuru Court in 2017. And so, my lord, the commission cannot be vilified for following what the court said is the law. All it was doing is following the law as interpreted by the courts. And so, my lord, there is a small issue of the manner in which a candidate should withdraw. My lord, the law has always been that if you look at the elections law, the formalities attending to every step is very well set out. So that, my lord, if you want to be a candidate, there are steps that must be followed. You will be given a certificate of nomination, you will be gazetted, and so on. If you also wish to withdraw, my lord, there must be formalities that attend to it. And that is why, my lord, the candidate was told that there is a requirement to fill a form before he can be, the commission can respond to his purported withdrawal. And the reason for that is simple. If you look at Regulation 52, my lord, which is the only regulation that deals with withdrawal pursuant to a nomination, it requires the candidate wishing to withdraw to do it within a period of 3 days. And that is because there are consequences attaching to being nominated as a candidate, and particularly financial implications. Because what needs to happen is that ballot papers have to be prepared. There is a cost to that. The technology has to be configured to include that person. So, my lord, for you to wait, for example, until 5 days or 10 days before the election and say now you wish to withdraw, my lord, would make it impossible for the commission to be able to conduct elections in accordance with the requirements of Article 81 of the Constitution. And that is why there is a requirement that if you wish to withdraw first, it's time-bound, and therefore, and secondly, there is the method of doing it, which was not complied with by that candidate. And so, my lord, I'm being reminded that my time was running. I was just starting to get on the roll, but I think